Hey everybody, how are you today? We're here today to do a quick video about the filing the state made today, this filing of a citation of additional authority. What it is essentially the state is adding another piece of case law. Just wanted to give the judges this additional case to consider while they are, making this decision. So the thing that's funny here, in my opinion, the first screenshot we're going to look at is basically them setting up what they're doing, setting up and talking about the case that they're going to introduce. And so it basically talks a lot about Brendan. It talks a lot about parallels between the case that he's going to cite and Brendan's and things like that. And I'm going to show you the screenshot here, but here's the question I have about Schimel that's kind of strange to me. Is, I don't know what he thinks about the case law that he's citing. Like, why does he think it's like Brendan's case? Because most of this case law that he is citing in his briefs and stuff like that, these cases are not really alike to Brendan's. A lot of them are, it's like he really only went looking in the case law for one factor. If the cases involve somebody that was 16 years old, and it seems to me he's just totally failing to consider that Brendan wasn't quite up to the speed of a normal 16-year-old. And I think that matters. I think it matters a lot. And I think I'm going to explain why further on in this video. And then the next thing is what is up with him putting these cases? All these cases seem to involve gang members. Most of them, anyway. I mean, you guys may know, obviously, if you're watching my channel, you may know I've been reviewing the case law that Brad Schimel and the state cited in their first original brief. The confessions that the cases that involved confessions that the state offered up. They offered up 4 or 5 confessions that the Seventh Circuit Court had deemed voluntary confessions, and he put up 2 cases in his first written brief that were cases the Seventh Circuit Court had deemed involuntary confessions, and AM versus Butler is one of those. And AM versus Butler is one of the ones that they talk about in the screenshot you're going to see here. It was also something that Laura Nyrider pointed at when she wrote her brief. She pointed at the fact that the state brought up AM versus Butler, which is actually closer in resemblance to Brendan's case than the other cases that they were citing. So, and I agree with her 100%. So, the thing is you got to remember with this is that gang members and Brendan are going to have pretty significantly different backgrounds. Sorry, but that's just obvious. I mean, and the reason why that's important is that if you've heard me talk about in my other videos about these false confession cases, is that there's a thing called the totality of circumstances in the AEDPA, determining of whether or not a confession is voluntary or not. And what those factors are is age, experience, intelligence, background, the defendant's ability or the appellant's ability, or, well, basically it would have been a defendant at the time when they were being Mirandized. The defendant's ability to understand his or her Fifth Amendment rights and what it means to waive those rights, and also understanding what it means when you give a statement to police. So these are all the things of whether or not, with all these circumstances, was this individual in a proper place and state of mind where they could give a voluntary confession. So that's what they consider, and background is one of those factors. And yet I've seen at least 3 of the cases that he cited involved these young gang members. So I don't know if that's because most of the cases that end up getting to the court system and getting up this high into appeals and stuff, a lot of the kids that are getting involved in these cases tend to be gang members, because that lifestyle leads you kind of to having to go to court or jail or prison or whatever. I don't know. I mean, I'm not sure why it's so many like gang members that it seems to get cited in his briefs or in his case law. Sorry, but nevertheless, it's something I noticed and I thought was odd because significantly different backgrounds on that. So the other thing he says coming up in the screenshot is about Barb. He claims that Barb was given the chance to be there, but that she gave permission for them to question Brendan. Well, thing is, I don't really agree with that because number one, on the 27th when they were interrogating Brendan or questioning Brendan, or actually when he was coming in as a special witness, right? Anyway, she gave them permission to take him out of school, or actually to go question him at school, and then she met them. She after work went over and met them, and then they all went over to the police station. But they told her to stay out of the interview room. They, gave her some line about, oh, he's going to give us some gruesome details and whatever. So she didn't like it. But I gotta imagine she felt intimidated because, you watch. I mean, just look at Colburn on the stand when Strang is pinning him down. You see it when you see him go. When I was watching that part, I was just like, come on, Colburn, hop out of there and just go for his neck. Not because I wanted to see him go for Strang, but because I wanted to see him, betray himself. Because he looked like he was real close right there. But yeah, you can imagine how intimidating these guys probably were. I mean, I feel bad for Barb. I mean, this situation is just a train wreck for her, Brendan, and I think ultimately for the state of Wisconsin. But, last thing here, I want to bring up that that comes up in this next bit I'm going to show you is he claims that Brendan is relying heavily on AM versus Butler, that piece of case law. The funny thing about that to me is that he cited it. He cited it in his first brief. And then when Laura Nyrider did her brief, she just pointed at it. So she's pointing at a case that was in his brief. And he's trying to say that they're heavily relying on it. I don't know. Not seeing it. Not buying it, Braddy. Anyways. So I'm going to go ahead and put that clip up for you guys right now so you can see it. And then we'll come back. Dear Mr. Agnello, under Federal Rule of Appellate Procedure 28J, respondent appellant submits Murdoch versus Dorothy. The primary issue in the present case is whether the Wisconsin Court of Appeals reasonably held that Brendan Dassey's confession was voluntary under AEDPA's stringent standard of review. Murdoch versus Dorothy further illustrates this court's deferential posture under the AEDPA as applied to challenges to the voluntariness of juvenile confessions. In Murdoch, the 16-year-old petitioner admitted to his involvement in a shooting during a 3-hour interview. In arguing that his confession was involuntary, Murdoch analogized to other juvenile confession cases, including AM versus Butler, which Dassey also relies on heavily. This court rejected Murdoch's argument that the state court reached the wrong outcome because the relevant inquiry under AEDPA is whether the holding was unreasonable. Even a different conclusion in light of similar facts does not render a state court's application of law unreasonable. What is important is that the state court applied the correct test in the reasonable manner. This court explained that the state court reasonably weighed Murdoch's age, absence of a concerned adult, the waiver of his Miranda rights, the 3-hour interview, that Murdoch was allowed to eat and use the restroom, that the officers did not threaten or otherwise create a coercive environment, and that Murdoch did not appear to be under distress or frightened. This reasoning is directly applicable to the present case. The Wisconsin Court of Appeals similarly considered that Dassey was 16 years old, that his mother gave permission for the interview, that Dassey was properly Mirandized, and that the interview took 3 hours. that he was offered food and beverages and restroom break, that the investigators did not use hectoring threats or promises of leniency, and that Dassey did not appear to be agitated or intimidated. Okay, so that was basically the state's opening, its introduction to its piece of case law that it was introducing. So we're going to go into a little bit about this case here. What happened here is, in Illinois, Mr. Murdaugh and two of his friends, I guess two of his friends got him to drive them somewhere. Apparently he claims he didn't know where they were going, but they went to a park or whatever, and he knew that somebody they didn't like was there. He said they pulled over at the park or whatever. He said, and then according to Murdaugh, his friends suddenly produced weapons and exited the vehicle. He said a short time later he heard gunshots, and then his friends got back in the vehicle or whatever and said take off or whatever. So that's basically what happened with this case. They got him to confess, or he confessed that he drove this van and drove these two guys, his friends, over to where they could kill this person. So that's how he got on the hook here. He's basically just a driver. So but that's what he claimed happened or whatever, basically, when he gave his statement to police. So the person at the park they were in their car and they ended up being shot fatally, and so they ended up picking up Murdaugh and his two friends apparently. And the interesting thing is that he had a mistrial twice because of a hung jury. And then on the third try they eventually got it. The jury went ahead and voted guilty, and he got 85 years. It's 2 consecutive sentences, one for second-degree murder and another for assault and battery, which was like 8 years or something like that. I don't know. Anyway, the thing that I find interesting is that he claims that when he was arrested, that he was handcuffed in the car, in the cop car. He was not Mirandized. This is what he claims. And he claims that on the way to the station that Officer Mushinsky is the officer involved here. That Officer Mushinsky was asking him questions and kind of already digging into him about this murder. So that to me is a problem, because that's not recorded. That's done out of the eyes of everybody. Who knows what he said? He could have been saying to Murdaugh at that point in time. That's what bothers me about that. Murdaugh claims that at that point that Mushinsky told him that if he gave up the trigger man, that he would get to go home. That's a promise. The court essentially decided that it wasn't true. They didn't find it as factual. They chose to go with the Officer Mushinsky's account of events, and they didn't believe it, so it didn't get considered. But here's my concern. My concern about it is that we don't know what happened at Fox Hills. They have a whole night with Brendan there, pretty much, where we have no idea what was going on, what they were saying. It's out of the eyes of where anybody could possibly know what happened there. So that's, to me, a problem. Just like it is in the trip in the car while this kid was handcuffed. Murdaugh was handcuffed in the back of the car, and the cop was asking him questions, maybe intimidating him and stuff. Away from prying eyes. Basically just him and the suspect there. Mushinsky and the suspect there. So he could, who knows what could have possibly been said or done and whatever. So that's all I'm saying there. Just could be something to that. So, but like I said, it leads me to say, what happened? What were they doing with Brendan at the Fox Hills Resort for a night where it's not documented, it's not videoed or anything? I'm really curious about what took place there. So, I mean, and also getting on to talk and going back to them saying that they gave Barb the opportunity to be there and stuff like that. Well, she was there at the Fox Hills Resort. They could have done whatever they needed to do then, and say, hey, well, we're gonna question Brendan or whatever, and she could have been there. She was at the Fox Hills Resort with all of them. They were all there. Yet they chose to do the interrogation on Monday. No doubt because they felt that Barb would probably be at work or something. And it happens she wasn't at work, but she had to go to court. She had to go to court for some divorce proceedings or whatever. And she didn't get out until like almost 2 o'clock. Like 1:30 or 2 o'clock or whatever. Most of the day is almost over by that point. Plus she had to travel from the courthouse wherever she was to wherever they were, which PlayStation, wherever they were. 2 Rivers, I believe it was. And so by the time she's getting there, she had no chance to be there, and here's the other thing about that. She gave permission, all right. She gave permission for them to take Brendan out of school. But she said, only if you take him back. Because she didn't know that they were interrogating him as a suspect. She thought that they were questioning him as a potential witness. So she said, as long as you're taking him back, you have my permission, right? They didn't take him back. In my opinion, that nullifies Barb's permission. So in my mind, they did not have permission that day. Sorry, plain and simple. Because they were getting Brendan to say incriminating things on Friday, or on February 27th. They got him to say like that he saw toes or whatever and stuff. Yeah. So they knew what was going on Monday. They knew that they wanted to wait until Monday because they didn't want Barb around. Plain and simple. Because, like I said, she was right there at the Fox Hills Resort where we have no record of what even happened there. But she was, they could have done their whole thing that they did Monday. They could have done it there at the Fox Hills Resort. Or they could have just done it then. They could have gone to the police station then and done it then. They didn't. They waited till Monday because they were hoping Barb would be away. Barb would be at work. And, therefore Brendan would be defenseless. So, that's basically the way I feel about that. So, basically the court ends up determining here, in the screenshot I'm going to show you, this court ends up determining that Murdaugh did have the mental capacity to understand his situation, his rights, the proceedings, and he was able to make he understood enough to make voluntary statements and decisions. So that's fine and dandy for him, but I don't think it applies to Brendan, like I said, because it seems here to me, like I said before, that Brad Schimel is deliberately ignoring the fact that Brendan is not on par with the normal 16-year-olds at his age at the time and stuff. He wasn't on par with them. And all the cases that he does cite of involuntary confessions are all kids under 16. All of them, pretty much. Every case he cited as involuntary pretty much so far, except for maybe one. Okay? So those are the cases that Brendan is more on par with. So as I read his case law and stuff, I don't know. I mean, I'm not a lawyer, so I guess I don't get the nuance of it, but his case law, in my opinion, doesn't seem to help him much. But maybe that's just me. So, anyways, I'll go ahead and show you now the clip of what I'm talking about, and then we'll come back again. Petitioner testified that he was handcuffed during the traffic stop and taken to the police station. He stated that Mashinsky began to ask him about the shooting without first reading his Miranda rights. He testified that Mashinsky told him that if he gave up the trigger man, he would be allowed to go home. Petitioner stated that he made requests to see a parent or a guardian to both Mashinsky and another officer at the station. He agreed that Mashinsky read the Miranda warnings before the video statement, but said that he did not fully understand them. The petitioner testified that he felt tired and scared while making the video statement. On January 28, 2010, the Circuit Court denied the motion to suppress in an oral ruling. The court held that although although he was a juvenile petitioner, he had the mental capacity to understand the situation, the proceedings, his rights, and to make voluntary decisions and statements. Okay, so now I'll introduce the next screenshot I'm going to show you here. Is Murdoch is going to show where Murdoch showed 3 examples of confessions that the Seventh Circuit had deemed involuntary. And those examples are Haley versus Ohio, Gallegos versus Colorado, and AM versus Butler. Haley was a 14-year-old, I believe. Gallegos was a 15-year-old, and AM was an 11-year-old. And in my opinion, all of these cases, first off, all of these cases are involving kids that were under 16 years of age. The Seventh Circuit found these confessions involuntary, and they all just happen to be under 16 years of age. Not saying that the Seventh Circuit always does that when they're under 16 years of age, but just saying when they go looking for cases that were deemed involuntary, it seems they're pulling up cases where the kids were under 16 years of age. So. And the reason why I think that's important is because, in my opinion, Brendan was more on par mentally and, emotionally and stuff with those kids, those younger teenagers. They have a lot of the same circumstances as Brendan. They all have like absence of a friendly adult. They have, somewhat, at least 3 or more hours interrogation time. So, I mean, there's just a lot of those similarities that run through Brendan's case with these cases, but the fact is that Brendan's more mentally, in the realm of those younger teenagers than he is of the normal 16-year-olds, like the ones that Brad Schimel keeps citing in his briefs and in his case law, where it's these really, really savvy 16-year-olds, these kids that are just real streetwise and stuff, and so they know what's going on when they're at the police station because them and their buddies talk about the cops and whatever. They have a awareness of it. So that's where background and all that stuff and the totality of circumstances, I think that's the crucial thing here. That's the real crucial thing in all of this, I believe. So anyway, I'm going to go ahead and show you now that clip, and then we'll come back one more time. In support of his argument, petitioner attempts to analogize the facts of his case to a case in which the court and the Supreme Court of the United States found the confessions of juveniles to be involuntary. Specifically, petitioner points to Haley versus Ohio, Gallegos versus Colorado, and AM versus Butler. In Haley, a 15-year-old confessed to a murder after he was questioned by police from midnight until 5 a.m., without an attorney or other adult present, and without being advised of his right to counsel. In Gallegos, a 14-year-old confessed to an assault and robbery after being held in a juvenile facility for 5 days, during which time he did not see a lawyer or any other friendly adult. In Butler, a 10-year-old boy confessed to murdering his neighbor after he was interrogated multiple times without his mother or another friendly adult present. In all 3 cases, the courts evaluated the totality of the surrounding circumstances and determined that the confessions were involuntary. Hey everybody, okay, so now here we go for the wrap up. You see there obviously what I'm talking about, that the cases that he's citing as involuntary confessions that the Seventh Circuit deemed involuntary are all involving kids that were under 16. I don't know. Anyway, the reason why I think that's important is because obviously Brendan may have been 16 as a number, but I don't think he was really on par with most of the 16-year-olds that at that time. I think he's more akin to some of these younger teenagers that are cited in the case law that Brad Schimel is citing. So it's interesting. Basically, I just gonna wrap up by saying, it just seems to me that Brad Schimmel is maybe a little desperate. That's what I don't know. I don't know what this is, but it seems to me that like maybe he's getting a little bit desperate because of the amicus brief. The Michi Karai brief, and that this is just like some kind of scrambling or whatever, just trying to bolster his case in whatever way he can. I mean, it just seems to me like scrambling or desperation, but I don't know. We will be looking forward here to a citation of additional authority from Laura Nyrider as well. It says that she will have a chance to respond. I'm sure it will be her to this citation. There's rules for it. It has to have a little brief introduction, and then the body of the citation itself needs to be 350 words or less. So we can be expecting 350 words or less from Laura Nyrider in the near future. Well, maybe a little more because you count the introduction. But anyway, so we can be expecting that, which is cool. We can look forward to that. I love reading everything she writes because I just think she's great. So anyways, that's about it, everybody. I hope you enjoyed it. And I hope if you haven't already, please hit subscribe.